The appeals chamber considers that, contrary to what the appellant argues, the trial chamber did not hold that his position of leadership in the joint criminal enterprise was an aggravating factor as such, but rather found that, I quote, "The fact that Babić held and remained in high political positions counts as an aggravating circumstance." The trial chamber thoroughly considered the appellant's behavior as a regional political leader and stressed that it considered his leadership position as an aggravating circumstance because he used his authority to enlist the resources of the Serbian Autonomous District Croatia to further the joint criminal enterprise, made inflammatory speeches during public events and in the media, which prepared the ground for the Serb population to accept that their goals could be achieved through acts of persecution, and amplified the consequences of the campaign of persecutions by allowing it to continue. The trial chamber did not consider the appellant's position of authority alone. It considered that position coupled with the manner in which his authority was exercised. The appellant's seventh ground of appeal is dismissed. Under the eighth ground of appeal, the appellant claimed in his notice of appeal that the trial chamber erred in law and in fact and abused its discretion in that it grossly misconstrued the scope of his role and participation in the joint criminal enterprise. Nevertheless, in his appellant's brief, he merely reiterated the arguments he presented under his third and seventh grounds of appeal. The only distinct argument which the appeals chamber addresses for purposes of clarification is the existence of a purported policy in this international tribunal which would render a plea agreement meaningless in that it would enable trial chambers, amongst other things, to disregard the sentencing recommendation made by the prosecution without giving any reason for departure from it, and to disregard the facts as presented in a factual statement without providing any reasoning as to why such facts are rejected. The notion that such an alleged policy exists in this international tribunal is unfounded, and the appellant does not substantiate any of its alleged elements. In cases of guilty pleas, trial chambers must, pursuant to Rule 62 bis 4, determine whether there is a sufficient factual basis for the crime and the accused's participation in it, either on the basis of independent indicia or on lack of any material disagreement between the parties about the facts of the case. End of quote. In the case of a plea agreement, a trial chamber enters its finding of guilt on the basis of the facts agreed by the parties, as set out in the indictment and in the statement of facts. It cannot therefore be said that a trial chamber can at the sentencing stage simply disregard those facts, which are the basis of the finding of guilt it enters. Furthermore, although a trial chamber does not have the discretionary power to impose a sentence higher than the sentence recommended by the parties, pursuant to Rule 62 ter B of the rules, which expressly states that trial chambers shall not be bound by any agreement between the parties, it also has a duty to take into account the specific context of a plea agreement in which the accused admits his guilt, and to give due consideration to the recommendation of the parties. A trial chamber cannot simply, as alleged by the appellant, ignore such recommendation and depart from it without providing reasons for such departure. In the present case, however, due consideration was given to the appellant's admission of guilt, and, as the appeals chamber has already found when assessing the second ground of appeal, the trial chamber did not ignore the facts contained in the factual statement and did not fail to give a reasoned opinion for its departure from the recommendation of the parties as to sentence. Therefore, the appellant's arguments pertaining to this alleged policy issue are unfounded, and the appellant's eighth ground of appeal is dismissed. Under the ninth ground of appeal, the appellant argues that the trial chamber erred in law and in fact and abused its discretion by basing its decision upon events and facts which occurred and arose outside of the temporal scope covered by Count 1 of the indictment. He contends that the trial chamber misconstrued his role as being responsible for persecutions on 1/3 of Croatia's territory. The appeals chamber finds that the temporal scope of the crime and the objective of the joint criminal enterprise were properly referred to by the trial chamber, and that the appellant's arguments are based on a misunderstanding of the trial chamber's findings. The trial chamber never implied, as the appellant submits, that the territory of the Serbian Autonomous District Krajina covered 1/3 of the Republic of Croatia. The appeals chamber, therefore, finds that the appellant's arguments in this respect are without merit, and the appellant's 9th ground of appeal is dismissed. Under the 11th ground of appeal, the appellant mainly contends that the trial chamber improperly based his sentence in part on the conclusion that he did not recognize at all times the significance of his role with respect to the armed conflict in Krajina in 1991 and 1992. He argues that the trial chamber erred in law and in fact and abused its discretion in imposing an impermissible and undefined burden of proof upon him to, I quote, convince it that he had at all times recognized the full significance of the role he played in Croatia in that period. The appeals chamber does not find that the trial chamber imposed an impermissible and undefined burden of proof upon the appellant, nor that it erred in considering a failure to convince the trial chamber as a reason in imposing sentence. Had the trial chamber intended to make a finding to the effect that the appellant did not fully recognize that he was indeed a co-perpetrator in the joint criminal enterprise charged, it would not have been able to accept the guilty plea pursuant to Rule 62 bis of the rules. In the appeals chamber's view, the statement in question is related to the parties' submissions concerning the fact that, due to the secondary nature of the appellant's role in the joint criminal enterprise, his participation in the crime was limited. Under the present ground of appeal, the appellant in fact incorporates, by reference, the arguments he already put forward concerning the proposition that his role was more limited than the trial chamber found it to be. As the appeals chamber already found that the appellant did not demonstrate a discernible error by the trial chamber in its assessment of his limited participation in the crime to which he pled guilty, there is no need to expound further on this aspect of the present ground of appeal. The appellant does not put forward any new argument for the consideration of the appeals chamber. The appellant's 11th ground of appeal is dismissed. I shall now read the operative part of the appeals chamber judgment. And I ask Mr. Babić, will you please stand? For the foregoing reasons, the appeals chamber, pursuant to Article 25 of the Statute and Rules 117 and 118 of the rules, noting the respective written submissions of the parties and the oral arguments they presented at the hearing on 25th April 2005, sitting in open session, allows unanimously, in part, the appellant's 6th ground of appeal, in that it finds that 1. The trial chamber erred in finding that the appellant's conduct subsequent to the crime of persecution could not be considered in mitigation solely because it did not include the alleviation of the suffering of victims, and 2. The trial chamber committed an error of law in not taking into account the appellant's attempts to further peace as a mitigating circumstance. Nevertheless, the appeals chamber finds by majority, Judge Mumba dissenting, that on balance, this error does not have an impact upon the sentence. Dismisses unanimously each of the remaining grounds of appeal filed by the appellant. Affirms by majority, Judge Mumba dissenting, the sentence of 13 years imprisonment as imposed by the trial chamber. Orders, in accordance with Rule 103C and Rule 107 of the rules, that the appellant is to remain in the custody of the International Tribunal pending the finalization of arrangements for his transfer to the state where his sentence will be served. Madam Registrar, would you please deliver copies of the judgment to the parties? Having concluded the issuing of the judgment, the appeal chamber will stand adjourned.
All rise. Veuillez vous lever.